So welcome to, I think, the last breakout session of the day. I'm Cathy Bump with Expedia, and our panel today is on online and mobile tracking. I'll give my fellow panelists a chance to quickly introduce themselves, and then we'll get started.
Okay, I'm Christopher Mesnooh. I know a lot of you in the audience. I practice privacy and IT and corporate law out of Paris, where I've lived for the last 23 years. And I've worked with a large number of companies in this part of the world.
Hi, I'm Saira Nayak from TRUSTe. I'm the Director of Policy there, and I believe we work with a number of companies in this room. I really focus on the external laws and regulations pertaining to privacy and data protection that impact our products and solutions. And formerly was at Microsoft, where I segued from being an antitrust lawyer to a privacy lawyer, which I think was a good move, and also practiced before that with the state AGs.
Hi, Michael Page from Durie, Tangri. I'm a intellectual property litigator. I've defended a few of your companies in privacy actions. Have been doing quite a bit of the sort of tracking and cookie slash UDID slash privacy class actions lately, entirely on the defense side.
Mimi Rasmussen. I am Chief Privacy Officer for Adobe Systems down in San Jose.
And I should say I'm Senior Privacy Counsel for Expedia. I have global responsibility for privacy. So before we start, we were interested to know how many people in the audience are inside counsel. Just raise your hands. Oh. Okay. Okay, good. Probably a majority. And how many in private practice? Okay, and how many students?
Wow.
Okay, oh wow. We're all in the working world. And then how many of people in inside counsel, how many are with startups? Okay, great. Okay, so we'll calibrate based on that and hopefully provide a lot of helpful information for you today. So a couple of I guess I'll start with a couple of baselines here, set some context. The panel before us touched on government access to information and the implications of that. So we're going to focus on the commercial, the business, the private collection and collection of tracking information and the issues involved with that. And another point I'll make is there's so many aspects of tracking that one can discuss. I mean, there are a lot of discussions about, whether the internet is free and therefore is tracking a legitimate price for users to pay. What's the value of that? Is that a fair exchange? That's outside the scope of what we're going to talk about. We're going to take as an assumption that tracking does occur, and we're going to go from there. So to start the discussion off, the question I'd like to pose first to my fellow panelists is what we mean by tracking. And let's just quickly talk about sort of what it is we're talking about here.
I'll start. So when you hear the term tracking, if you're carrying what the FTC says, the FTC tends to talk about tracking in terms of OBA, online behavioral advertising. And in that case, they're talking about tracking consumers over time across websites for the purposes of serving targeted ads. So when the FTC, usually when we're talking about tracking, that is what is often referred to. From a practical matter, if I talk about my practice in Adobe, there's all sorts of other types of tracking. There's tracking online for analytics purposes. There's tracking for purposes of personalizing a website. There's tracking for market research. There's personally identifiable tracking. There's anonymous aggregate tracking. So that's what tracking means. Does that make it's a huge definition, and when you're talking about it, you really need to understand which type of tracking you're talking about.
And I would add, we're now seeing a lot more of much more literal sense of tracking as we go less desktop and more mobile, which is geolocation information, literally where you are when and where you've been.
Yeah, and I think when you talk about tracking in the online context, and especially the best practices context, you also need to think about providing transparency and choice. And of course, that's going to differ on the type of data you're collecting, whether it's personal or not, whether it's pseudonymous data, or whether it's sensitive.
One caveat to just what Saira just said is you don't always need the choice, and that's when you have to understand what kind of tracking you're doing. You almost always need transparency, but you have to do some kind of analysis to figure out, depending on what you're doing, whether or not choice is required.
So, and I'll just follow up on one point that Mimi made, that it does differ from country to country or region to region. What is the focus of tracking? So as she mentioned, the FTC has focused on the The FTC has focused on tracking for behavioral targeting purposes, but in Europe, in fact, the focus has been much broader, and while there's a recognition that it might be more seriously raising privacy implications when it's advertising, purposes such as analytics and so on are not excluded by the EU regulators when they focus on tracking and consent and notice by any means. So, and I should also say that if people have questions throughout our panel, we'll try to keep things moving so that we do have time to respond to your questions as we're going through this. So we're hoping it'll be very interactive both among ourselves but as well with the audience. So I encourage you to don't be shy and go ahead and raise questions that come to mind. So following up then on what we mean by tracking, another obvious question is whose responsibility should it be? We mentioned here that, the concepts of notice and choice and transparency. There's been a lot of discussion in this area as to whose responsibility it is to provide that kind of notice and obtain consent as necessary. So what are our thoughts on that?
I mean, I think from my perspective as a litigator, it's the responsibility of whoever can get sued. Is the simplest answer. If you are the outward-facing person to the consumer, and you're the person who's going to be in the New York Times article that spawns the class actions the next morning, you shouldn't be relying on your vendors to make sure they're doing the right thing. You shouldn't be relying on a browser or browser settings to do the right thing. You should be doing the right thing yourself. The right thing is not necessarily not tracking. It's making sure that you've told people what you do. And one of the biggest risks when you do that is, particularly, I saw very few startups. The companies that have the biggest problems are sort of in the mid-range where you've grown. You've acquired 27 other companies. You're not quite big enough to have a huge in-house privacy group, but you're growing. And all of a sudden you realize that your code has pieces that have been put in it by about 50 different people, and there's no one left in the company who even knows who they were. Every time you've made a deal with an advertiser and you did a test for a couple of weeks and then you decide you didn't want them, they plugged something in. They may still be dropping cookies. Every time you did a deal with somebody else, there's another API. One of the things you learn, I learned as an outside counsel, is every single time, the first time you ask an engineer what's going on in the code, you will get the wrong answer. Right? Inside counsel won't get inside litigation counsel won't get the full facts from the product counsel won't get the full facts from the engineers, outside counsel won't get it from anybody. The upshot of that is make sure you don't make promises in your privacy policy about things where you don't know what's going on in your code. Just make it really broad. In the previous panel, somebody referred to, having a privacy policy that says we only use your information in order to provide the service we provide. If you're going to say that, make sure you explain that part of providing the service you provide is paying for it, and that using that information in order to pay for it is a permitted use, unless you're really, really, really sure you're not doing it. And most people don't know.
So that's a good point. I think one of the things that you brought up as part of your statement just there was the idea that whether it's your obligation or not to be disclosing, you want to be certain that you're not making inaccurate statements, and that in addition to whether you may have an obligation to disclose or not, you need to think about to what extent you need to be controlling and at least yourself be aware of what's happening on your site. As we go through today, we're going to discuss a couple of different approaches that have been surfacing these last years for providing notice and disclosure. We have the EU cookie directive, we have do not track, and as we go through those, you'll see illustrations of the different approaches, because they're not just different approaches from the consumer perspective, but they also take very different approaches on who takes the responsibility for making those notices. So that might be a good segue to go to talk a little more about the EU cookie directive. And Christopher, as our visitor from Europe, is going to go give us a little bit of context for that, and also show us some illustrations of how companies have gone about complying.
Great. Okay. Yes, okay. I'm very mindful that it's 4 o'clock in the afternoon on a very warm Friday afternoon, and that when people talk about EU privacy issues, sometimes there's great interest and sometimes people just roll their eyes. So I'm going to try to find a mid-ground between giving you some information in the context of the do not tracking part of this program and the way things are done or not done in Europe. In thinking about how to present this, I was trying to think of an analogy that might speak to most of the people in this room. And I think given what the average age here seems to be, if I go back to the Y2K phenomenon, I think most of you will remember that, where people spent a great deal of time fretting about what might have been one of the great computer bugs of the century or of the millennium. And in fact, it passed pretty smoothly, all things considered. And the reason I mention this in the context of talking about the 2009 cookie directive is because as a build-up to the 2009 directive, most of my American clients were calling and emailing frantically, asking me what compliance would entail, what the cookie directive actually was aiming to accomplish, and of course, most importantly for lawyers, what would happen if compliance was either overlooked, forgotten, or incomplete. So let's just take a quick look at what the cookie directive attempts to accomplish. It's attempting to accomplish the following. Any consumer or user on the internet who is looking at a site onto which cookies are placed, either first-party cookies, third-party cookies, session cookies, whatever, that person has to be given clear, transparent, what's called user-friendly instructions about the existence of the cookies, what purpose the cookies are serving, and the possibilities of turning off the cookies. So in theory, it's pretty straightforward. In practice, it turned out to be somewhat more complicated. And the reason it's more complicated than it appeared to be at first glance was that the law that was put into place was a directive. A directive under EU law is a set of guidelines which then get transposed into the national laws of each of the 27 member states. So in the context of the cookie directive, we actually wound up with 27 similar but not identical transpositions of what guidance users had to be given when cookies were being placed on their screens. The result is that some jurisdictions seem to opt for an opt-in approach, where a user says, I expressly agree that by continuing to look at this site, cookies are being placed and can monitor my viewing activity. Some jurisdictions speak more or suggest an opt-out approach. And other jurisdictions say, well, if you tell people that they can play with their web browser and configure the web browsers to eliminate or turn off the cookies, that will be sufficient. The result has been it's been pandemonium across the European Union. And as a result, the level of compliance is variable. Equally interesting, perhaps more so for those of us who practice law in-house, the number of complaints and legal or regulatory actions that have been taken on the basis of violation of the cookie directive has been extremely low. I did something this morning just for the fun of it. I went onto the French websites of 25 large international companies, American, some of whom are represented in this room, Asian, French, and European. And I was interested in seeing how many proposed opt-in for their cookie rules, how many presented opt-out, how many spoke about the possibility of going back to the web browser to turn off the cookies, and how many said nothing at all. And the statistics in this highly unscientific sampling, I think, are very, very interesting. Of the 25 sites I looked at, 8% had a pop-up banner basically allowing for opt-out. 32%, 1/3, either said nothing at all, or they spoke about the possibilities of cookies being manipulated via your web browser, but didn't actually indicate to users how to do it. And roughly 2/3, about 60%, told people how to go into the web browser and how to actually turn off the cookies if they wanted to turn them off. So in the best of circumstances, again, on this highly unscientific sampling, we have compliance ranging anywhere from 2% to 30%. But for the 2/3, the 60% or so that don't tell people, for the 1/3 that don't tell people how to turn off the browser, or even that cookies are to be, the cookie settings are to be found on the browser, you've got clearly 1/3 which is in violation of European law. What have the sanctions been? The sanctions are what they are for any violation of privacy in the European Union. The amounts are phenomenal. They start at several €100,000 in the case of a country like France. The UK recently upped sanctions to £500,000. But how many actual sanctions have been levied in the context of cookie violations? I did a research last week, and I found virtually none in the 4 or 5 jurisdictions I looked at. So, to conclude, I would say that, and I'd say this more generally about EU privacy law, the goals are laudable, the methodology is chaotic, and the compliance is at best erratic. Maybe just before turning it over to Mimi, this is really just more for the fun of doing a quick around the European Union. We started with my firm's website. We take this kind of seriously. This is one model that people can or cannot use. But I wanted to give some foreign language examples of pop-up banners indicating the existence of cookies, and in some cases, what can be done if people decide they don't want cookies to be activated on their computers. So we have Air France. We have a fairly detailed one for one of the large French banks. We have a law firm, a Dutch-Belgian law firm. We have the German National Railway System. We have the Italian National Airline. We have a pharmaceutical company based in Spain. And we have a trading site in Italy. And in all cases, you can see that the pop-ups are varying in length and in detail. But if you want to be more or less in compliance, my recommendation would be come up with some version of one of the pop-ups and don't simply include in a lengthy description in the privacy policy how you can go onto the web browser and how you can turn the cookies off.
Christopher, I have a question actually following up on that. So it seems to me that between the idea of the pop-up and burying it in the privacy policy would be just a link. I don't actually know if any of your examples or Mimi's example shows that, but a separate link to a cookie policy, perhaps somewhere above the fold,
Correct.
as opposed to in the footer. What do you think about that? As you know, since we're talking about best practices, we're
Yeah.
talking about avoiding litigation.
Okay.
Where would you rank that, as prudent or not?
I think the further you get away from the banner approach and the more you bury this information in general terms and conditions, the more likely you are to get a tap on the knuckles if anybody ever notices or if anybody ever complains. You know, we're in the United States. I think most of us are American qualified. I certainly am. This is an enormously litigious society. Things are not done quite the same way in Europe. There are not class actions per se in many jurisdictions. There is not a plaintiff's bar, as we understand in this country, to prosecute violations of privacy law. So the sanctions, such as they are, almost inevitably arise from the national regulator. This brings us back to the problem, Cathy, of having 27 regulators with different cultures, different levels of business friendliness or business hostility, that in fact there really isn't one size fits all. And so I think what practitioners such as myself, what we recommend to Americans in particular, is an 80-20 rule. Basically, if you feel that you can get 80% in compliance with the overwhelming amount of detail and regulatory framework in the European Union, you're actually doing pretty well. 100% is achievable, it is expensive, and it is horrifically complicated.
Okay, thanks. So Mimi's going to go through a few more examples of what we've seen companies do, and these are focused more in the UK and Ireland, I think. And I will say that the UK regulator, I think it's fair to say, the UK regulator provided probably by himself, that office provided as much guidance on this topic and what was expected on the compliance front as all the other EU regulators combined. So if you are interested in learning more about what's been happening over the last probably 18 to 24 months, the ICO site in the UK is a good resource. They put out, I think, several papers talking about exactly what they were looking for.
And there's just basically a lovely little footnote that I looked at this morning where the ICO says basically because this has not been a big deal and we've not gotten a lot of complaints, we're going back to basically a business-friendly and a business-pragmatic approach, which you will not see on all of the other DPA websites.
Which is a great segue to the first slide that I'm showing you. This was the way the ICO, that is the regulatory body in the UK, first came out with it. They were one of the very few, and the only one I really saw, that required you to specifically accept cookies before they would set them. So you'll see in the upper where I've circled, it says, I accept cookies from the site. If you did not check that, they would not set cookies. And there were some interesting statistics that came out of the UK after this. They had analytics running on their site, which obviously used cookies, and they had visibility into how their site was being used until the day they put this on. And the minute they put this on, their visibility into how their site, there was a chart that just went, because nobody would check off the box to set the cookie. So they had no visibility into how their site was being used. So after a while, they came out with this right when the law was passed because they felt they were interpreting it as strictly as possible. They realized that that really wasn't working very well. And they, too, now have changed. So down at the bottom, they say, we place cookies. To learn more, go here, change your settings, and they take you away. So if you're worried about whether to get actual opt-in consent, as Cathy said, take a look at the ICO site for guidelines as well as for what they do. The Irish presidency, on their site, just as I went to some government sites, they did this. It wasn't an opt-in. It was basically saying, we use cookies, and you'll receive cookies. You can change your settings. HP went quite a bit further, but they did they set the settings the way they wanted them, but they broke them down into the usage of the cookies. So we use them to personalize your site. We use them to show you ads. If you don't like the way we've set it, click here, and you can change it. This site in Ireland is one that the Irish DPA actually called out as a decent effort at compliance. And it is pretty much doing what a lot of the other sites are doing, letting you know that they set cookies and link you to where to change the settings. Yahoo, similarly, I'm trying to remember what they did. They did it pretty much the same. We use cookies. By using the site, you agree to it, but go change. One of the most extravagant sites in terms of compliance, and they really did, this site has been called out a lot in good compliance. They created icons for the different types of usage of cookies, whether it's strictly necessary, whether they're performance, whether they're functional cookies. And the first time you go there, you'll get a little hover. If you want to really see an interesting site, go to the BT site. When you click on BT down at the bottom, it's not on my, yeah, on the bottom right, you'll see a notice about the cookies. And when you click on it, you get taken to this site, which has a slider. And as you slide the slider to the left or to the right, what shows up underneath, it will tell you what you get. When you set your cookies to this level, we'll do everything. We'll send you advertising, we'll do analytics, we'll do strictly necessary, we'll do performance-based, et cetera. If you really are very privacy-centric and you slide it all the way the other way, it's going to show you all we're going to do is the strictly necessary, and it kind of walks you through how to do it. So this one has been held up as obviously an excellent site, but we haven't seen too many other companies doing this. So that was just a few other examples in English that you could see.
Thanks, Mimi. So moving now from EU cookie directive, which is what's a little bit past history almost now. Also, we're still waiting to see what regulators are going to be doing, but I think that the focus of attention has shifted somewhat or is growing on do not track. And Mimi's going to talk about that, and that's really breaking news. Even as we speak in the last weeks, there's been developments. So Mimi, why don't you give us some background there?
Like Cathy, can I just ask a question at first? How many of you are following do not track and have a pretty good sense of what it is? Okay, not that many. Okay. So let me start a little bit from the beginning, but try to do this quickly. So do not track has been started being mentioned back in like 2007. It came up when the FTC had done the do not call, and that went over so well. People were getting very concerned about online behavioral advertising, and the FTC said, hey, as did Senator Rockefeller and some others, let's do a do not track. Do not call was easy. Everybody understood it. Let's just do not track. Industry, go take care of that, will you? And yeah, that didn't go so well. So there were a lot of developments, but one of the most significant developments is that the W3C, the World Wide Web Consortium, a standards body in the web world, they created the HTML spec. They create all the standard specifications for how to do things online on the web. They decided that they would pick this up and that they would define what do not track means. The W3C is a consensus-based standards organization, which is very important in this context. The people who decided to join the working group for this standards organization were a number of the common industry partners. Adobe is on there, Google, Yahoo. A lot of industry players are on there. We have university professors on there. We have privacy advocates on there. There are some DPAs from Europe sitting on there. And keep in mind, I said this was a consensus-based organization. So 2 years later, many extensions, we still do not have a standard, because getting that group of people, some of whom actually have to implement the standard, some of whom are really looking out in their minds for consumers, it's been difficult. And one of the difficult things is that the term track has not yet been defined. Although I should preface that. 2 weeks ago, a new draft of one of the specifications for this was submitted, and we finally had a tracking definition put in, but it hasn't been agreed upon yet. There are 4 weeks left for this standard body to continue working on it unless the parties agree to extend. I believe, sitting on the standards group and watching these meetings, that it is unlikely that it will get extended, which will be really interesting, because a lot of companies now are out there. So let me back up for a second and say what do not track is. It is not a cookie-based regime. It was implemented at first by Mozilla in the browser. And what they said, if you go to your privacy settings in the Firefox browser, there is a setting that says, I can't remember the exact words, but it's something like, tell websites I do not want to be tracked. But tracking isn't defined. So when that box is checked off, a header is sent down along the pipe to websites. It's not a cookie. It's just information that gets sent down the pipe to websites. Websites are supposed to check for that and then honor it, but it's on the honor system. They don't have to, it's not law. So what has happened along the way, after Mozilla did that, Microsoft, about a year ago, decided that they were going to change IE to set do not track on by default. And that set up another firestorm of debate. Because the whole purpose of do not track, starting with the FTC and the way the working group in the W3C had set this up, was the do not track header was supposed to signify user's intent, what a user's choice was. Well, if Microsoft went off and set it by default, it was no longer the user's choice. And so the working group started to talk about, is that compliant or not? Because there was some terms in the specifications that said, that defined what that header was sent down, how it was sent down, was to indicate user choice. And so most people are now thinking that that is not a compliant browser. What has progressed over time is that it has been realized that with about 13 or 14 lines of code, anybody can put a do not track signal in. So AT&T might do it, ISPs might do it, any kind of user agent can send that down, and websites won't know if the user chose that or not. So one of the big holdups with the debate right now is, do you have to honor that setting when it's a non-compliant setting? But we don't know, there's no way to determine whether it's a non-compliant setting. So that has been a huge part of the debate. So with all that as the background, what we've started to see is browsers and other entities taking this into their own hands, because they're realizing if the W3C do not track effort does not stick, then how are we going to protect users' privacy? Several weeks ago, Mozilla came out and said that they would turn on by default not to set third-party cookies. But there were some caveats along with that. But they decided that, like Safari, which right now does not let you set third-party cookies unless, how many people know what a third-party cookie versus first-party cookie is? Okay, so not everybody. So real quick, first-party cookie, if you come to adobe.com and adobe.com sets a cookie on your site, it's a first-party cookie. It's the adobe.com domain. You went to the adobe.com domain. We set the cookie. That's first-party. If while on adobe.com we had DoubleClick from Google setting their cookies so that they could track people and set an advertisement somewhere else, that DoubleClick cookie, when set on adobe.com, is the third-party cookie. It is those third-party cookies that the FTC and others and privacy advocates are most concerned about. And so those are the cookies that Safari by default does not set, and that Mozilla has said, although they backed off a little bit, but what they've said they will likely do in the future is not accept those third-party cookies.
Wouldn't it be worth differentiating between cookies that the third party sets as a service provider for the first party? You mentioned one company, they act sometimes as a service provider, sometimes they act in their own interest. And I think if you hire them as a service provider, because cookie is 94 competency, then that's still a first party cookie if it's only used for Adobe's purposes. If you hire another company to do that for you.
And I'll pay you later for asking that question. That is something that has been discussed at the W3C, and in the specification for do not track, they set aside service providers. And the reason I said I would pay you later is Adobe, in one of our parts of our business, is we are a service provider, and we do often set third-party cookies. So the problem is that under the way Mozilla was planning on implementing it in the browser, if you just stop setting third-party cookies, it hits the service providers as well. And they've realized that it's a really blunt instrument to solve a difficult problem, and they've backed off a little bit, waiting to see how this goes. But one of the other latest developments is something right out of Stanford. There is the Cookie Clearinghouse, which was just announced, which is why Cathy said it's changing daily. I was just on the phone today as I was driving in with hearing some new developments. So Stanford has set up this Cookie Clearinghouse, which will be comprised of just a few people to create whitelists and blacklists. And if you're on the whitelist, it reminds me of an old Dr. Seuss book I read to my kids. If you had stars upon Mars. So if you have a whitelist, if you're listed on the whitelist, your third-party cookie gets to go through. If you're on the blacklist, your third-party cookie does not get to go through. And I went up on their website. I can read you. They came out with 4 rules of how they would propose to set this. If a user visits a website and sets the cookies from that site, those are okay. So that's they purposely went to that site. That's more of a first-party use. If a user does not visit a website, you do not set the cookies from that site. So that my example of going to adobe.com to double-click, the double-click wouldn't get set. If a site is trying to save a DAA opt-out cookie, so people opt out of receiving certain things like advertisements, those opt-outs are stored in third-party cookies. So those opt-out cookies will be allowed to be written and saved because they're serving a privacy function. And if a user consents to setting a cookie, obviously those cookies would be allowed. So we're waiting to see how this works out. They're working in conjunction with Mozilla. Mozilla has said that they are waiting to see how they define this, and then they'll work with them. Industry is keeping a very close eye on this because you've got a handful of individuals setting policy. And to be honest, what scares me a little bit is that if the do not track effort fails, we've got 4 weeks to find out if it fails, then this cookie clearinghouse is out there defining rules of when cookies can and cannot be set. And if Mozilla follows that and says, we will do it this way, then what that does to the rest of the browsers and the pressure that puts on the browsers on whether or not to follow the cookie clearinghouse is a little scary, especially if you look at this from a worldwide perspective. Chinese cookies, German cookies, cookies in all different types, for all different types of reasons. The implications of this, when you stop and think about it, are really quite large. So the industry and everybody on the Do Not Track working group are looking very closely at how this is going to be set, who the parties are who are making these decisions, and what the other browser companies have to do with this.
I mean, well, my first reaction to that, and I think the biggest concern with that is you're taking out the ability for website operators to be advertising supported no matter how transparent they are with their users. In other words, if you have a clearinghouse and the browsers, and between them they are knocking out all of the third-party cookies, unless there's consent from the user, most users will go, no, I'd rather get the free service without the ads. It's no longer an informed
it goes back to what I was saying
model,
about
right?
Microsoft setting the default.
It's consent rather than disclosure, and it will. The world is used to getting everything for free on the internet, and this, I think, kills that ability.
This will be an interesting one to watch over the next. It's going to be happening in the next month or two.
But this doesn't just apply to browsers; it applies to every site, right? So every nonprofit that has.
It applies to websites. So remember, it's how the browser, when the browser will write a cookie. So if a user is going to a not-for-profit site within a browser, the browser is deciding when to write that cookie. And so if you've got third-party cookies on a non-for-profit site that falls into this bucket, yeah. Now, there's talk, I haven't, how they're going to scale this, because clearly it can't be done manually, which also worries me, because if it's not done manually and they come up with rigid rules that gets automated, that automation isn't going to catch everything, and then there would need to be a petition to get onto the whitelist, but there might be rules that the clearinghouse requires. If you want to get on the whitelist, you might have to, we don't know. We don't know. So that's why Cathy was saying, I mean, this is literally changing daily right now. Well, I can just tell you what I've read. I haven't yet spoken to the person who's heading this up, although I do plan on doing that in a week or so. The way they've announced this is that they will control this with a whitelist and a blacklist.
Yeah, my understanding is there's going to be some sort of spec. So for instance, they'll say, this is a first-party cookie, this is a third-party cookie, here are the exceptions if the third party is a service provider. But that's what they're negotiating, sort of the DNT working group, the W3 working group. That's what they're trying to negotiate.
You can go online. I can show you. I just did a Google search to try to find what they had, and all I did is Google search for cookie clearinghouse because I wanted to see exactly what they had. And if you do that, you'll find it, and you'll see what they're currently saying, and you can keep your eye on how they're doing it. But it's very early. They just announced this a week or so ago, and I can't quite figure out the scaling. I mean, the world is a very large place with a lot of cookies. But this isn't just Europe. This is worldwide. Because, yeah. Yeah. Well, there's a lot of other third-party cookies out there other than, there's survey cookies.
Cool.
No. Yeah, it's what I call the catching the dolphins in the tuna net.
Yeah. The problem is that the sharks have found like a whole lot of better ways to do this than cookies. So it's fighting 5 years ago's battles.
Yep.
Most of the people who are using cookies tend to be fairly visible and fairly decent actors. The really nasty guys have moved on to the 10 other ways to track people.
So Christopher, do you have a perspective on how this might be seen in the EU? I mean, the fact that WC3, how they're looking at that group, and if that doesn't succeed, how they may view this effort, or?
I think there's a recurring tension in the European Union that I think we talked about this before. On the one hand, every survey undertaken in the EU suggests that people are very attached to their privacy, and that anything which will allow them to increase or enhance their privacy online is something that they want to be able to use. And on the other hand, when things actually come into the market, and we don't yet have anything this sophisticated, but you take the cookie directive, which attempts to protect online privacy, and you see from what I based my comments on before, that the actual amount of interest in this tool is extremely low. So I think the kind of de facto compromise in Europe is, yes, we want our privacy protected, and yes, we want the tools to protect our privacy, but when you actually have all these pop-up banners, and when you have these things, these instructions telling you how to go and turn off cookie settings on your web browser, the fact of the matter is that survey after survey shows that very few people actually avail themselves of it.
Yeah, TRUSTe has a consent manager product which we use for EU cookie directive compliance and also for trusted ads. So if you see the little eye icon here in the US for OBA ads, and I believe the click-through rate for that consent manager is like 0.5%. So that is the percentage of users who really care about privacy and are taking the extra step to click through.
And that, at the risk of stating the obvious, that illustrates the importance of these fundamental questions. Is it going to be an opt-in? Is it an opt-out? Do you force the user to make a choice? Because people, there's a certain level perhaps of apathy about privacy when it really comes down to it, or at least not enough interest to necessarily make a proactive choice. Okay. So a little hard to predict because this is still evolving, but Mike, one of the things I think would be useful is to sort of talk through what you've seen and what you would predict as far as litigation risk, and maybe also the FTC if you want to talk about that too.
We saw a huge spate, of course, over the last few years of privacy class actions. There are a couple of major firms that bring them, but there are dozens of copycats, and for about 3 years, the pattern was, first there was, I forget her name, who was doing the monthly series with the Wall Street Journal, which fortunately the Pulitzer nominations closed, so she stopped running them. But it was once a month. And the New York Times also would every once in a while run some privacy expose, and immediately there would be, in multiple courts around the country, multiple lawsuits filed the next morning with a sort of hacked up version of the allegations that they'd read in the Wall Street Journal or the New York Times and no other investigation. And those are the ones we've been defending. They all end up MDL'd if they get filed in 20 different jurisdictions. Most of them have ended up out here because of, most of the defendants are out here. To date, I have yet to see one make it through a contested class certification motion. Most of them settle for just under the transactional cost it would take to win them. The main defense is that there's no Article III standing because there is actually no economic harm to people. They've sort of migrated off of the cookies to UDID stuff, to address book stuff. Most of them look at what did your privacy policy say versus what did you do, and oops, you let this out, or you missed this, which is, again, why my advice is don't make promises in your privacy policy just because you want to look like a nice guy unless you're really, really sure they're true. The only people who read those privacy policies in any detail are the plaintiff's bar to make sure that you didn't screw up. Your users don't really care what's in them. They don't read them. One of the things that's slowing down the litigation, though, is that the courts are being a lot stricter than they were a couple of years ago about scrutinizing settlements, right? Because most of these settlements are, an illusory, coupon, coupons for these people if they sign up, or behavioral changes, or something where if everybody signed up, you'd have a dollar value that looked like $9 million so that the plaintiffs can get $900,000 in fees. The take rates on them are fractions of 1%. So judges are sitting there looking at these cases where there is no economic harm. There's a very tiny take rate compared to the fees, and federal judges are required to figure out, did we get the best benefit for the class? And that's really hard for a judge to do when the class actually wasn't harmed economically, and therefore there's no way to assess whether they were reasonably compensated. One of the solutions people have turned to are Cypress solutions, where it's, you agree to give, $100,000 to each of your 5 favorite law firms, law schools. We've had several instances where judges interjected an additional donation to their alma mater, whether they do any relevant work at all. But the courts are being very strict on that now and saying that it has to be a reasonable substitute for a compensation to the class, not just somebody who does good work. And I'm seeing more and more often courts are making plaintiffs come back 2 and 3 and 4 times on preliminary approval of class settlements and requiring much broader notice and really trying to grind down the plaintiff's bar on jumping through all the hoops of Rule 23. I had one case that was a cookie case that we settled. We settled it within a day or two. We went through a year of preliminary approval, including 6 hearings in Los Angeles before we got preliminary approval, when there were no objectors, nobody opposed to it, just the judge trying to give them a hard time. I think the courts are trying to discourage frivolous class actions. I don't think they recognize the fact that all they're doing is raising the cost to the defendants. But it's becoming a less lucrative opportunity for plaintiffs just because courts are being much stricter on reviewing settlements. The other thing that's cutting down on them is the FTC. There are more and more FTC enforcement actions against guys who are actually bad guys, who are doing, instead of having just made a mistake by not putting the right disclosure in their privacy policy, they're sucking data out of back doors, they're selling credit card numbers, they're doing the things that you really worry about in privacy cases. The FTC is jumping on them fairly quickly and getting them into consent decrees. So I think the perception among judges and among the public in general is that there's much less need for the plaintiff's privacy actions because the really bad guys the FTC is going after.
Okay, thanks. So shifting now, oh, question?
I have one quick question. With the cookie cases, the majority of them are ECPA, is that correct?
Some are ECPA, some are, the immediate defense is Article 3 standing, that there's not, right? So to plead around that, plaintiffs try to claim either an ECPA violation, a Stored Communications Act violation, or a CFAA violation, or some federal statute. They don't really fit.
That require intrusion,
Right.
right? My follow-up question is are we in less risk when we're talking about non-cookie-based tracking, browser, fingerprinting stuff, that doesn't actually put anything in a user's system? Are we creating more risk or less risk? Because that's not an intrusion. By passively collecting things that are just
My view is that none of these come anywhere near satisfying CFAA or the Stored Communications Act. So, it's sort of the difference between a 0 and a 1% risk. But, but courts are getting more proactive in looking at the allegedly statutory violations and going, wait a minute, this is only here because of Article 3 and it just doesn't fit, and they're throwing them out usually.
So we've highlighted some ways in which this world is ever evolving, and we'd like to close with a look at some innovations that we see coming down the pike, and we'll start with Saira.
I just wanted to also add on privacy policies for those of you that work in the mobile world. It is worth looking at a short notice format. There are several out there. The Department of Commerce is also coordinating another multi-stakeholder proceeding around mobile short notice, so it's definitely worth looking at that. Going forward, and someone brought up browser fingerprinting, I think another best practice is innovating around privacy challenges. So TRUSTe, we've actually just announced something we've worked on with a company called AdTruth, familiar to some of you. I don't know if anyone from AdTruth is in the audience, but they have a device identification technology that is a probabilistic technology. So it's not like a cookie, which is deterministic and can sort of identify a particular device definitively. It's more a combination of factors that AdTruth will look at, are you on a Wi-Fi, the same Wi-Fi network, your geolocation, things like that, and they will determine with 90 to 95% probability that it is your device. When AdTruth first launched with this technology, there was a lot of blowback. It was device fingerprinting. I'm sure some of you may have followed that story. And so they came to us and said, how can we do this in a privacy-sensitive way? And so the challenge here is really advertising on the mobile platform. Of course, the mobile web has cookies, but mobile apps don't. So there's really not a consistent way to register both a user preference and also to target ads. TRUSTe, through our consent manager, which we don't have a screenshot here, but it's kind of similar to the BT consent manager you saw earlier. We will drop a first-party cookie on any user that accesses that consent manager, and then we, of course, keep those preferences. So what AdTruth did is they, connected with us, and we basically, when AdTruth will serve an ad on the mobile platform, they will first check to see whether there's an opt-out registered with TRUSTe. If there is an opt-out registered, then they will not deliver a targeted ad, and if there is, so if there is an opt-out registered, then they won't deliver a targeted ad, and if there isn't, then they will. So this is, there's a pretty complicated deck in the materials. I didn't want to geek you all out at this late hour in the day, but take a look at it. It's basically a schematic of how the system would work. There's the trust provider, which could be TRUSTe or any other company. There's the device ID technology, which those technologies are evolving. Now we're getting into this probabilistic realm. And then, of course, working with the ad service or the ad network to actually deliver the ad. So we may be seeing more of this on the mobile platform going forward.
So Saira, this would be then, the audience for this would be an ad network that wanted to respect the privacy of users on their mobile devices. Is that?
Or as well, so it could be an ad network, it could be a data service like a Quantcast, for example. It could also be the device ID technology, whether it's a probabilistic technology or a deterministic technology. The key here is fingerprinting the device or identifying the device, but also offering that opt-out, so you have that transparency and that control for the user.
Okay, thanks. So we're almost at the end of our time. I don't know, want to go down the road and just sort of say a few closing words? Or does anyone else have any other thoughts on the innovation that we may be seeing in the near future in this area? I just open it up.
Well, from an in-house perspective, I'll leave you with the mantra that I came up with for my in-house for all of the employees when I do privacy training at Adobe. Something that I leave them with so that they can easy to remember. So to stay out of privacy trouble, say what you do what you say, and don't surprise the user. By the end of my classes, I have them singing it. And they leave, they know what that means. And it's really, that's all it boils down to. Say what you do what you say, and don't surprise the user.
And you are still at a significant random chance of being sued based on something some third party did, or something, or some piece of reporting that was wrong, or a plaintiff's counsel that misread the piece of reporting that was right.
Spoken as a true litigator.
It's the best you can do. It's, that risk is always out there, but it's not a big one.
Oh, does anyone want to top that note of doom and gloom?
Well, I just also wanted to say, would echo what Mimi said. I mean, privacy is all about expectations, at least here in the United States. So, companies out there have the opportunity to shape that through education or how they design their products. And one of the things that some companies are looking at is how can we get beyond the tracking hurdle? Can we track a user in a way that really benefits them? Like, how many of you would like to be tracked so that you could get a discount for shoes at your favorite store, or your favorite cosmetics, or for the guys in the audience, I don't know, whatever guys buy nowadays. But that's the sort of paradigm that definitely a lot of retailers are looking ahead to. What happens when we do get that full consent from the user? Can we then really track them in a way that's beneficial for us, because we get to learn more about the user, we get to have a data relationship with them, but also keeps the user informed about what's going on?
I would say that one of the things that strikes me when I come and speak in America, which is fairly often, is how much attention is paid to privacy. The general conception in Europe is that this is a privacy wasteland, and that but for the European approach, the planet would just be basically just a completely inert, from a privacy perspective, sphere. In fact, many of the concepts that my colleagues have spoken about, there is an equivalent on the other side of the Atlantic. The one thing I'd say to the Americans in the room, which would appear to be the vast majority, although not 100%, is that there's a different approach overseas. It certainly is bureaucratically heavy. As most of you probably know, the current law is being reworked into something called a regulation, which will have immediate effect across the European Union. Hopefully all of these national disparities will disappear. There's been a great deal of hostility in the United States to the regulation, which is beyond the scope of this afternoon's panel. But I would argue that it's actually in everybody's interest in this room that for what goes on in Europe, that there is a coherent, one-stop shop approach, which is understandable, and that you don't have to come to somebody like me and ask for 27 different analyses for how to comply in Europe. So I think the concepts are actually getting closer, and I find it very encouraging.
Okay, thank you, and thanks to for your attention and your questions. I guess we'll move on for the last presentation of the day. Thank you.